My name is Abigail Seymour. I'm a child custody and family law attorney in Greensboro, North Carolina. And today I want to talk about a topic that comes up a lot and is somewhat misunderstood, which is emergency custody. A lot of people will call my office and talk to us about asking for emergency custody. And when I find out a little bit more, it's often, well, the other party has withheld my child. My child is over at her dad's house and he's keeping her and he's refusing to let me come get her. This is a very distressing situation, of course, and in another video I talk about how that should not happen, not by you or by the other party, because withholding the children for no good reason is not okay. And the downside is when you don't have a custody order yet, that is legal. So you have inherent constitutional rights as a parent, and therefore if there's no custody order, that person's not breaking any laws. They're allowed to have their child for however long they want. Where it gets complicated is where there is truly an emergency, and there is a part of our statutes in North Carolina that allows for a court to make a very, very quick and or swift decision to allow a party to have temporary emergency custody right away. However, because that's such a big move to make, there are only 3 instances that it can be even considered. And some of our judges will be very clear about that and hold up their fingers and say, do you have the 3? And that's because there's really only 3 ways. One of them is, and these are all very distressing concepts to even consider, but one would be if you have very strong reason to believe that your child is in imminent danger of physical harm. And that can be in all different flavors of a sad story, of course, but if there is somebody who's an active alcoholic who is driving a car with the kids in the back seat and you know this, or the kids are without, I mean, you can imagine all the different ways that a child could be at risk of imminent harm. I think where it gets a little bit complicated is, well, the other party doesn't always have baby gates, or they don't always cover up electrical outlets and things like that. That's harder to prove as an imminent risk of physical harm. That's tough. So you have to really understand that that's a very serious. This is burning with cigarettes. This is pretty serious stuff. So that's number 1. Possible grounds for emergency custody would be imminent risk of physical harm. The second prong or possible reason for getting emergency custody is imminent risk of sexual abuse. Again, very serious allegations. You instantly are going to be involving the police department, DSS, forensic interviews. I mean, this is very, very serious stuff, but that's because this is about protecting children. So if that's a real thing, then it needs to be addressed immediately, and a judge will take that very seriously. The third reason, which has a little bit of a gray area, like most of these things do, but is somebody who is, when the child's at risk of being taken out of the state for the purpose of avoiding the courts. And that's, again, it's a little complicated because obviously if you don't have an order yet and the other party is about to leave the state with your child, kind of depends. Have they cut you off? Have they told you they're leaving the country? Are they fleeing? Are they never going to let you see your children again? Or is it like, hey, listen, I'm moving, I got a job in Atlanta. If you don't have an order in place, that's it's a little bit more complicated. It's about whether or not the motive behind that person's move is to stay away from our courts, to basically avoid punishment, avoid consequences, things like that. So emergency custody is a very rare action. It's not a rare action, but it's a rare, it's something you can't just grab off the shelf when you decide that you're not seeing your child enough. It's kind of a specialized part of what we do, and for the reasons I've just named, it's very serious. So anyway, I hope that's helpful to help you understand what that really means, because there's a whole process that goes into it. It's not just, hey, I need this. You have to get a special order, a judge has to sign it. There's a lot of moving parts to this, but again, there's only 3 grounds that it can be granted. Oh, and by the way, at the end, it's not forever. You know, within 10 days, the statute says that you have to go in front of a judge so that the other party can say, whoa, hey, hang on a second. Or so the judge can say, yeah, that was 100% warranted, and I'm going to continue this order. I'm going to grant it for a longer period of time, etc. So I hope that's helpful. And if so, please like this video and subscribe to my new YouTube channel. I have a hard time saying that. My YouTube channel. Please subscribe to my YouTube channel. And also have come and like our Facebook page. So thanks for listening.